Mr. Chairman, the subject of today's meeting is pretty profound, related to the rule of law, and there are so many examples that some of us point to, and it's hard to name them all. So I'm just going to point to a few that this administration seems to have stepped outside the boundaries of, quote, the rule of law. Taxing political contributions, again, not in the law. Political speech disclosures for federal contractors. The deep water drilling ban. Mr. Holder's attempt to reform criminal justice by selectively enforcing our laws. Mr. Obama's unilaterally ignoring immigration laws in many cases. Recess appointments, unconstitutional recess appointments. Fast and Furious, were unconstitutional efforts there to walk guns. Unconstitutional wiretaps by of the AP. The IRS scandal, one of the more egregious ones, as the gentleman mentioned, that it subverts the entire political process. And, of course, Obamacare, which I'll touch on in a moment. But all of these are examples where this president, in the words of my friends on the left, has exercised prosecutorial discretion. That's the word. Presidential pardon powers. But I think they're more along the lines of Professor Turley said these could be considered royal prerogatives, which is, if my history is right, that's what we had that little unpleasantness with great. So the subject here is of profound significance. And I would suggest, Mr. Chairman, that not only in the application of the law has this administration held themselves unconstrained by the Constitution or even the truth in many cases, but even in the process of getting the law. On Obamacare, this was passed in a unique situation where I see in Mr. Cannon's testimony especially, it's probably the perfect citation. I see in your testimony that you write, President Obama's unfaithfulness to the PPACA is so wanton, it is no longer accurate to say the Patient Protection and Affordable Care Act is, quote, the law of the land. And, it's kind of ironic because some of my colleagues, about 53 of us, have signed on to the House resolution stating that we believe that Obamacare has yet to be the law of the land because it violated the origination clause of the U.S. Constitution when it was passed. And we don't talk about that a great deal, but it is significant because the origination clause, which was vital to the Constitution ever coming into existence in the first place, it was the critical negotiation that took place to allow the Constitution to exist, requires that all bills for raising revenue originate in the House. And incidentally, Mr. Cannon, your colleague Ilya Shapiro at Cato has written an excellent piece at laying out this argument. I'm going to ask that this be placed in the record here in a moment, and also would like to ask you to address it if you have a perspective of it. But the bottom line that is at issue here is that if the U.S. Senate can take a totally unrelated piece of legislation and strike everything but the number and take legislation that they call the Senate Health Care Bill and place it in its entirety, which raises taxes to an enormous degree, if they can take any bill in the House and do that, then I would suggest to you, especially after the Supreme Court has labeled Obamacare a tax, they've officially called it a tax. And if indeed it can be done this way, then I would suggest to you that the origination clause is a dead letter. There is no more purpose for it being in the Constitution. And it's something that I hope that we'll look at a little more carefully. So if it's all right, Mr. Cannon, I'm going to address my question to you. Do you have anything that would help illuminate this in ways that the rest of us can understand?
Well, this is a provision of the Constitution that hasn't really been used or employed by the Supreme Court to knock down any revenue measures that were alleged to have originated in the Senate instead of in the House as required by the Constitution. I think that what happened with the PPACA is a more extreme example of the abuse of a more extreme violation of the origination clause than what we have seen in the past. As you say, a bill came up with a totally unrelated revenue measure came over in the House, from the House. The Senate stripped out everything within that bill, kept only the bill number, H.R. 3590, I believe, and inserted into that the Patient Protection and Affordable Care Act, which had all sorts of revenue measures, including the individual mandate, which we didn't know then was a tax, but now we know it is a tax until the administration changes its mind again, which it continues to do. There's nothing in the bill number that's a revenue measure. That's not, all the revenue measures had been stripped out of that bill. So if the origination clause means anything, then it means that that revenue measure that the Senate passed and then the House passed and that we now call the Patient Protection and Affordable Care Act originated in the Senate, and the Senate did not have the power to originate a bill, a revenue measure like that. So, but the difficulty is, will the courts enforce that part of the Constitution? There is a difficult line to be drawn between when are you amending a revenue measure that came from the House and when are you originating a new bill. I think that reasonable people can disagree about where that line will be drawn. I don't think that reasonable people can disagree about whether the Senate's gutting of H.R. 3590 and inserting into that a totally new revenue measure is on. I don't think anyone can disagree that that is on the wrong side of that line. It remains to be seen whether the courts will uphold that part of the Constitution. If they do, then probably they would have to strike down the entire PPACA. Fortunately, there is a lawsuit that's making its way through federal courts. It's been filed by the Pacific Legal Foundation that challenges the individual mandate as under the origination clause.
Mr. Chairman, thank you. I guess when if this administration does not succeed in stacking the D.C. Circuit, we should find out whether the origination clause still means anything at all with the case that the gentleman mentions.
I thank the gentleman from Arizona. The chair will now recognize